Hello everyone, my name is Tomas Vazquez Rojas, Research Assistant at the Cyberjustice Laboratory at the University of Montreal. Thank you very much for joining today's webinar, Legal Tech and Access to Justice, Thoughts from the Estates Planning Context. We have the pleasure of welcoming Emily Taylor Poppe from the Irvine School of Law, University of California. So Professor Taylor Poppe, I give you the floor.
Thank you very much. Let me just start my slideshow here. Oh, I'm sorry. Okay. So thank you so much for the invitation to be here. Bonjour. I apologize that my French is non-existent, so I will be presenting in English. And today I wanted to share some thoughts with you about legal technology and access to justice from the context of estate planning. I'm coming to you today from Irvine, California, here in Southern California, where it's a few hours earlier and probably many fewer degrees warmer. So thank you again. It's such a pleasure to be here and to be able to join you. I wanted to start today by explaining a little bit about how I became interested in access to justice. This is a picture of me graduating from law school, yay, many years ago. And after I graduated, I went to work at a large law firm in Chicago, where I did estate planning for high net worth individuals and families. And there, the families that I was working with had dynastic wealth that had often been passed down through several generations, and the hope was to pass them on to several more. These were individuals and families who had multiple advisors, lawyers, investment managers, family office, oftentimes. And their main concerns, in addition to kind of the normal concerns of estate planning about how to allocate property and caring for others, there were huge concerns. Sort of the overriding work was tax minimization and wealth preservation. So this was sort of the client world that I was working with. But because I did some probate litigation and guardianship work and also some probate estate administration, I often had to appear in probate court. And when I went to probate court, on various calls in the probate court, including decedents' estates and guardianship calls, it was a very different population. So in those courts, especially in the guardianship court, what I saw was a population that was disproportionately poor, largely people of color, very often dealing with non-traditional family forms. So individuals who, they might have been grandparents raising grandchildren, or other kin taking in children for various reasons. There were almost no lawyers, and the essential needs were really the primary concern of the court. So for example, I remember the judge, before she would assign anybody to be guardian of the person of a child, she would ask, is there a bed for everybody in the house? Is there food in the house? And so just completely two very, very different worlds, who were both needing estate planning, but had very different access to this type of work. So when I talk about estate planning and how it was sort of needed by all, but only possessed by some, I'm really talking about the use of legal instruments to control the allocation of property at death, and also to anticipate the potential for periods of incapacity during life. So at death, we think about allocating property. And by doing so, we also are able to then, individuals are able to avoid intestacy, which in our system are the laws that will determine who receives your property after you die, if you die without a will and without transferring those assets in any other way. And in recent work with my co-author, Megan Doherty-B, we've looked at how intestacy works differently for sort of traditional marital families than it does for other family forms, which are increasingly common. And so this need to sort of avoid these default rules is an issue that's really widespread and particularly among people who may have less access to estate planning. Estate planning also allows individuals to appoint an executor who will take care, who will administer their property after death. It allows them to nominate guardians for minor children. The court still has to assess whether those people will be appointed, but the nominations are very often important evidence in that and considerations in that process. For higher net worth families, tax planning can be involved, although the tax code right now in the United States means that you can be passing up to about $11.5 million without really getting into tax implications. Although we have a new administration, that might change. So that's sort of a higher net worth consideration. And then for incapacity, we're thinking about powers of attorney for finance and health, and advanced directives to determine what types of medical care somebody might want or might not want. So I was really struck by this vast inequality that I saw, and it made me realize I didn't really want to be a lawyer, among other things. And I decided to actually go back to graduate school. I got a PhD in sociology. And since then, my research agenda has really been focused on access to justice in a number of ways. I've done work thinking about the effects of having a lawyer across a number of different civil types of cases, and also specifically in foreclosures, a topic that I fear may become quite relevant to us again as we come out of the pandemic. And also access to lawyers, either through networks or looking at rates of pro se litigation. And then in the last couple of years, I've sort of made full circle and come back to thinking about estate planning, but through an access to justice lens. So in these articles that were published in the UC Davis Law Review and the Oklahoma Law Review, I've started to really think about who is accessing estate planning and what is the role of legal technology in providing access to this type of legal assistance. And I'm really going to be drawing on these two articles in my talk today. And my more specific focus in thinking about this is, can legal technology expand access to justice in the estate planning context, but starting from this perspective of more broadly? And I'm sure to many in this audience, especially people affiliated with the Cyberjustice Laboratory, I'm very much preaching to the choir, as we might say, that there is a huge amount of optimism about the potential for legal technology. Part of this is the idea that it will, by automating legal prediction, drafting, providing enhancing research, it will make lawyers a lot more efficient. And by making lawyers more efficient, the hope is that we can then expand legal representation into parts of the market that right now are underserved. The other reason for optimism is the idea that apps, online resources, forms provided online information, all of these things aimed at lay people will serve as a substitute for actual in-person lawyer assistance. And the idea there is that legal tech will really revolutionize self-help in ways that will expand access to justice. And at least in the United States context, there's coming with all of this, a lot of discussion about the regulation of the legal profession and how we can reform the ways that we police the monopoly of the legal profession through the unauthorized practice of law in ways that would encourage legal technology. And we see this kind of on the national level with reforms adopted by the American Bar Association, but also on the state level. In my own state of California right now, this is very much a topic that is in process. On the other hand, there's also reason for skepticism. So legal technology is developed where there's money to develop it. And certainly instances like the Cyberjustice Laboratory are a great exception. But in general, where this development is happening is largely to serve the needs of corporate clients. And so there's concern that the legal tech simply won't be developed to serve these types of individual legal needs, or that when it is developed, We see questions about its design, its efficacy, and whether people really can access it. And the concern is that as we develop more legal technology and as people come to rely on it more, it could end up diverting other types of resources. We could end up substituting out alternative sources of assistance in favor of legal technology, which could mean all of this together could mean that we replicate all of the existing inequalities that we have in access to justice, and we just move them over into the digital world. Or in a worst case scenario, we actually make it worse. So I come to this topic of then legal technology and access to estate planning, thinking about both this great potential, but also these concerns and skepticism about how it will really play out. And the optimism is really striking. It actually sort of makes me laugh a little bit, because if you read any new article or book talking about the great potential for legal technology to expand access to justice, I would be willing to bet that somewhere there will be a reference to wills, because they are just so often presented as the poster child for where legal tech is really going to make a difference. And so that's why I think it's sort of an important context in which to consider legal technology and access to justice, is because there is such great hope for it in this context. So I have here some quotes from McGinnis and Pierce, their well-known article from 2014. Trust in estate planning is already ripe for mechanization. Or Benjamin Barton, the most obvious examples of computerization are things like LegalZoom and Rocket Lawyer, and they provide forms for things like wills and trusts. Chains like Walmart and Tesco can sell wills. We can move to kind of the commercialization. And simple documents like living wills and powers of attorney can be prepared easily. So again and again, we sort of, we see estate planning as being a context where people have great hope for the potential for legal technology. And indeed, there is a lot of legal tech available. Some of it's pretty low tech. So this is a California statutory will. In the California probate code, there is a will form that's prepared as part of the statute. And now you can not just find it in the code books, which I'm sure everybody has easy access to all the law books for the state of California. You can find it online. So this is sort of a low-tech access to estate planning. But then we also have higher tech, things like LegalZoom, where individuals log on, they're asked some questions, and through this input, there's then a document created that people can print off and use. And I will note that there's actually thought about even more cutting edge tech, which is the idea that machine learning and big data could actually be used to personalize the intestacy laws. So this would be a way to avoid the need for estate planning altogether, because hopefully we'll get so much better at being able to identify your probable intent that you won't need a will, because you'll get this personalized intestacy and it'll basically do what you would have wanted. I think we are a long way off from getting here, especially just knowing about the lack of big data that's accessible in the United States in terms of wills. If you want to go look at wills, some places you can get them online, but some places you're going down in a basement somewhere and digging out paper files. So I think this is intriguing, but I think that's kind of a long way off. And so that's not really the focus of my talk today. So part of the question I want to ask is optimism about what? So optimism that legal tech can generate estate planning instruments doesn't necessarily lead to the conclusion that legal tech will actually expand access to justice. And that is what I really want to focus on, is why I'm somewhat skeptical about simply the presence of this legal tech is necessarily a sufficient condition to mean that we'll really be expanding access to estate planning. And more particularly, I want to talk about issues surrounding mobilization, boundary problems, capacity, and additional needs. So in terms of mobilization, I have here a New Yorker cartoon, and he's surrounded by paper and just says, I just need to get all my affairs in chaotic neglect before I die. And of course, we don't think this is what most people are doing. And yet at the same time, in the United States, less than half of all adults have even a will. So something is preventing people from mobilizing. And legal tech will expand access if a lack of access is what is actually the problem. If this lack of being able to get a will or a trust or powers of attorney is really what's preventing people from accessing estate planning. But I'm not sure that's true. So often part of the story about why we think legal tech will be so transformative is that it can be cheaper. But financial cost is rarely the reason that people give for not having an estate plan. Sometimes we think it's sort of psychic costs or avoidance is part of the explanation, that people don't like thinking about death or thinking about estate planning. It's not a pleasant topic. But at the same time, people do fill out all kinds of different forms that deal with this issue in other ways. So for example, beneficiary designations for insurance policies or retirement accounts, where a lot of people hold a lot of their wealth. They fill those forms out all the time, and we don't sort of have the same dimension. Important but not urgent, again, is possibly an explanation here, that we spend 90% of our lives doing things that are urgent but not important, and it's really hard to get to the important but not urgent. But again, there also might be this sort of desire for assistance, that wills maybe are sort of special, and the way people perceive them as being very much legal documents might be part of the bar here, in which case it's not totally clear, again, whether legal tech is going to motivate people or overcome those barriers. And then, of course, the other piece of this is that in order for the legal tech to work, people also have to be able to access it and implement it effectively. And that involves having internet access, being able to use the web effectively to assess whether a resource is reliable or not, to have the digital literacy to be able to navigate and engage with it. And Margaret Hagan and Becky Sandifer, a number of people are doing work pointing out these issues in raising concerns about the usability of legal tech. Another potential issue is the problem of boundary problems. And Ray Brescia and his co-authors bring this up, and they point out an approach that provides one-size-fits-all services without an appropriate screening process to identify potential complicating factors runs the risk of surrendering important rights. So back to my earlier point about how estate planning is kind of the poster child for legal tech. In most of those really positive, optimistic claims, the authors often sort of cabin their claim to refer only to simple wills. Legal tech is going to be great for helping people create a simple will. But the question is, do the people themselves have to know that all they need is a simple will, or does the tech have to be able to make that decision? Does the tech have to be able to say, your situation is too complicated, this technology is not sufficient to address your needs? Who is policing, and how do we police that boundary? And a related issue in the estate planning context is that wills control only property that goes through the probate court system. But property that it passes through other instruments, so for example, a joint checking account just passes to the surviving owner. A house that is held in joint tenancy. At the death of one of the tenants, it simply transfers to the other tenant who now owns the entirety. So all of these things, beneficiary designations, all of those assets pass outside of the probate process, and are not at all controlled by wills. And what complicates this somewhat is that for all unsecured debts, those debts do come due to the probate estate. So we can have situations where the bulk of the assets are passing outside of the probate estate, and yet the probate estate now suddenly has all of the debts. If people don't understand that bigger picture, it can really frustrate their intent. And the result can be an estate plan that's really not functional and not carrying out the decedent's intent. There's also a question about capacity. I don't have a lot of question about people's ability to know their own mind, but in order to assess what somebody wants in their estate plan, they have to consider several contingencies, because we draft estate plans with the hope that they will be effective no matter what circumstances change between the time of drafting and the time of death. And so to draft an effective plan, the person who's drafting the will has to actually think through all these possible contingencies. And a lot of the times in making those decisions, they're taking into account considerations that are soft goals, like family harmony. And that is not a particular strength of AI or other tech. Those soft, nuanced conversations are not something that we're likely to get soon, I think, from legal tech. The other challenge in legal tech and estate planning is that wills are what can be referred to as boundary objects, which means that they are an object that speaks to multiple audiences. So as lawyers, we think about wills in a very legalistic way. We want to make sure they can be easily constructed, easily construed and interpreted, that they're clear, that they're legally enforceable, but they are also very personal, and they are a message from beyond the grave in some ways to surviving family members. And so there's another audience that's present there. And that complicates, again, sort of the ability to just use formal tech to kind of address the needs. On the other hand, the question this raises, which is a question that comes up in much more broadly in thinking about legal tech and access to justice, is compared to what? So if we have a lot of people who have no access to estate planning right now, are they better off if they get an estate plan with some help, or are they not? And in estate planning is an interesting context where we have a system in place as an alternative, which is the laws of intestacy, which you might think of as sort of the best alternative to a negotiated agreement, the BATNA, the default if you don't actually engage in this estate planning. So the question then might be, is what we get through the use of legal tech better than intestacy? Or is the right comparison more bespoke legal help, that if you went to a lawyer and they drafted it for you, what would you get? And I don't have an answer to this question. I think it's really something that the whole access to justice community is sort of struggling to think through. How do we think about liability for legal tech companies, especially when their goal is to expand access? What is the right comparison for consumer protection purposes? And finally, there's also a question about additional needs. So Becky Sandifer did a large study of legal technology aimed at lay individuals in the United States. And she points out that many existing tools may be conduits of information, but only about half assist their users in taking any kind of action on justice problems by automating one or more tasks. And even those who do actually automate a task very often are going to automate one task, when in fact, to actually fully address the problem, there are several more tasks that also need to be completed. This is really obvious in the estate planning context, where not only do you have to write the will, you have to execute it. And the law of wills is incredibly, notoriously formalistic. And that is evolving over time. And yet we have very strict formalities. Attested wills have to be signed in the presence of 2 witnesses. They might have to be in the presence of each other and the testator when they sign. And ideally, these should be individuals who are not entitled to take under the will. So many people get tripped up in the actual execution process. If you want to later revoke or amend the will, the same formalities also apply. So it's sort of over the lifetime of the document, we come into this problem again. Another issue is legal competence, mental competence. Only legally competent individuals can make a will. And it is a fairly low threshold in the United States, that legal threshold. But especially when we get into the case of older adults or adults who might have somewhat diminished capacity, this can be grounds to contest the will. One of the benefits of working with a lawyer is that the lawyer can help to create a body of evidence to support the assessment that the individual was legally competent. We lose that if we move to a world of legal tech. Also, there's a question about enforceability. Provisions of a will that are against public policy or a trust are unenforceable and will fail. This is somewhat of a boundary issue too, of is the legal tech kind of policing this or not? And then even if we get through creating the document and executing it appropriately, when the individual actually dies, the estate has to be administered. So how do we think about probate administration, and what's the role of legal technology in helping people in that process? So to me, this raises a whole bunch of empirical questions. I'm an empirical scholar. I really want more data and more evidence-based assessment of this, because I would love for the optimism to be true. I would love for this to be a way to expand access, but I really want to have a better understanding of how it's working or how it's not working. And so some of the just kind of basic questions are how prevalent is the use of legal technology? Has it really infiltrated into the market? Do rates of usage vary by instrument? Do the rates of usage vary across segments of the population? And does the usage or the patterns of usage suggest that legal tech is actually sort of expanding access and increasing the number of people who end up doing estate planning? Or does it just substitute for other forms of service, leaving people who were underserved before still underserved? I don't have answers to these questions, but I do have a little bit of information that I'll share. This is information from a will study by David Horton. He collected wills that were filed in Alameda County, California, and also from San Francisco County. He found that just under 3% of wills that were filed in Alameda County during this period were software wills created through software. And in San Francisco, it was just under 4%. Now, how do we interpret this? How do we put it in larger context? We would probably expect this to be lower than the general population in many ways, because for one thing, the data from Alameda County is from 2008, 2009. It's about 10 years old. We would think the rates might be increasing over time. Also, we know that older individuals are more likely to have died. So when we look at, these are from actual wills from a probate estate of somebody who has died, then we know that's not representative of the whole population. It's just representative of the people who died in that particular time. And so to the extent we think younger people might be more likely to use legal technology, this sort of might be a negatively biased estimate of the general population. I have some additional light to shine on this a little bit. I did an online survey that was administered in the late summer of 2019. It was online and administered by Qualtrics with a sample just under 2,000. And it is consistent with national distributions for race and ethnicity, gender, income, and region of the country, but it is not a probability sample. And the content was about various questions about estate planning, utilization, reasons why people did or did not, and some other related topics. So just to give you a sense of prevalence of estate planning as a baseline here, I found that 43% of respondents had reported having a will, 26% had a revocable trust, 38% had a power of attorney for finance, and 44% had a power of attorney for health. So then what I want to know is kind of those people who have these instruments, how many of them use legal tech to get them? And that's this bright blue line. And interestingly, it's about 10% for each type of instrument. So about 10% of wills, 10% of trusts, about 10% of powers of attorney for health and finance were created using software or some other type of computer application. So then I wanted to look to see if I could see patterns in who uses legal technology. So the full sample, just to remember, was 1,975. Of that, 841 people had a will. Of that 841, 93 had prepared it using legal technology. So I have a limited sample size here, but I find nothing. I expected to at least see some patterns that maybe wouldn't achieve statistical significance given the small sample, but really not a lot in pattern. Men and women, it's 12 of the men who have a will, 12% use legal tech to create it, 10% of women, it's not a statistically significant difference. Race and ethnicity, slightly higher among whites and blacks, slightly lower against Latinos, but again, not a statistically significant difference. Household income, not any type of really discernible pattern. Education, pretty flat. Now, again, there are all of these things pattern whether people have a will. But once we net out kind of having a will, I don't see this variation in the use of legal technology to get it. Similarly, age, I don't see anything. What I will say that's interesting is if I look at use of all the different types, so if I kind of model use of legal technology versus a lawyer versus all of the other ones, what is interesting is there's a really strong relationship between whether your parents have a will and whether you go to a lawyer. So people whose parents have a will are very likely to also have a will and use a lawyer to get it, which I think says something about sort of inheritance of legal capacity. The other thing I thought I might see, or I might be able to at least get sort of a preliminary handle on, was whether legal tech might create kind of a more comprehensive estate plan. That is, if you use one of these programs, does it help you not only get a will, but also get a power of attorney for health and finance? Is it sort of a package deal that encourages people to get multiple instruments? And I don't find evidence of that. I find a lot of people who actually prepare different instruments differently. So there wasn't a lot of evidence of everybody's who's using legal tech is getting all of these things. And it doesn't, if you use legal tech to prepare a will, that doesn't help predict whether you have any of these other instruments. So I don't see evidence of that, at least in these data either. So, what I take from this, just sort of preliminary, a little bit first kind of empirical jump at this, is that I see it is being used relatively widely. I mean, 10% of people who have estate planning to me is a notable share, but we could ask compared to what? And maybe there's some evidence here, the fact that I find a higher percent than the will study, drawing largely earlier data. Maybe that's an increase over time or across different cohorts of people, but it's really hard to say because the data sources are so different. I don't see any strong evidence that it's resulting in more comprehensive plans. I can't really tease out variation. I don't see it across sociodemographic groups. But of course, this is all complicated by the fact that there's selection into having an estate plan at all and a limited sample. So that leaves room for lots of future work. So with new, bigger data, you could start to consider questions about changes over time. A really big question is, how is COVID going to affect this? The sad reality is that I think unexpected mortality has become just a more prevalent in our understanding of the world. and so could be increasing concerns and pushing estate planning. At the same time, it's a period that's also made it more difficult. It's harder to go to a lawyer. It's harder to get witnesses to execute a will because we're all virtual. We could see cohort effects. We could see period effects. So cohort meaning sort of the generation, the age you are at this time, but also that's kind of related to being in this moment. I mean, how do all those dynamics play out? With a larger probability sample, we could do more investigation of sort of the demographic groups that are being served by legal tech. And I think there's a lot of questions about kind of modeling mobilization to estate planning more generally, and kind of disentangling your legal capability, your life circumstances, your legal knowledge, your access to resources. How do all of those come together, and understanding sort of the feedback across those. And then there are lots of questions still out there about the success of instruments that are generated versus legal technology. Do they match testators' intent and understanding of what they're going to do? Are they enforceable? Do they miss key issues? And of course, in order to kind of get at these questions, we really have to ask the testators at the time they're drafting the instrument. We can't sort of wait until death to see if things blow up and there's litigation about the will, because we can't ask the testator what their intent was at that point. We've lost sort of that view into it. So I think there's a lot of room for new research looking at these practices in practice. So lessons more broadly for access to justice. My question, or the big point I wanted to express in this work, is the question isn't just whether the tech works. Can people find it? Can they use it? Does it know whether it can solve their problem? Does it help them do everything that they need to do? And then also, how do changing legal doctrine and regulation play into this? Because it's not just legal tech that's evolving over time and our comfort with legal tech. It's also the ability of legal tech to work and how laws are changing in response. So an interesting thing right now, because of the pandemic, states have imposed emergency measures about allowing people to use electronic wills. I think that's going to stick, even knock wood post-pandemic. Thinking about electronic signatures on wills, which have not been accepted in the United States, is that a move we're going to see changing? So I think the law is, these are always both moving at the same time, and taking all of that into account, and thinking about how optimistic we are about legal tech. So that is it. I welcome any questions or feedback people might have. Again, it's such a pleasure to join you today.
So while we're waiting on questions, I just some questions concerning your presentation, mainly on the second part where you show your findings on the collected data. Mm-hmm. But just first, I was wondering if you could expand on the reasons why estate planning became, like you said, the poster child for legal tech, because as you explained afterwards, when you touch upon all the skepticism that you have, it doesn't seem like a domain which is fertile for legal tech. It's very personal, very emotional. It touches family relationships, which, as you have said, is not a forte of legal tech. So why do you think that it has become the poster child?
I think in part because none of the people who are seeing it that way are estate planners. So I think part of it is that their view is this is really simplistic. Wills are super easy to draft. All situations are there. Nobody's all that unique. And so my own experience, having done this work, I may be biased too far in the other direction, and the truth may lie somewhere in the middle. But I think it's that people sort of see it as an area where it's just a will. It's pretty straightforward to draft. Don't most people kind of want the same thing? And so I think that's really what's motivated it. I don't see a lot of estate planners saying, this is, the greatest area for legal tech. I do think too, there's a real distinction between legal tech that helps lawyers draft versus legal tech that helps lay individuals address their needs. And I have no question that legal tech makes lawyers a lot more efficient in this area and automates drafting. But the self-help piece and the ability to do it on your own is kind of a different question.
And do you think, continuing on that, the tools that you have showed us, if I understood correctly, are more centered on the lay person? They are to draft a will for someone who doesn't have the knowledge required or the experience to do it. Do you think that this is the way that the legal tech is going to take, or do you think that with time we will realize that it won't help us match as we think the lay person, and maybe we will see more legal tech addressed to lawyers in order to help lay persons?
Yeah, it's a great question. I think this is an area where we're going to continue to see it. And the fact that, for example, LegalZoom has finally, I think, started to make inroads in being able to say, if you want to regulate us out, if you want to say that we're unauthorized practice of law, you're going to have to show that we're harming consumers, that we're messing up and that this isn't working. And I really welcome that, because it's possible that this really is working for the people who access it. And I think it may be a situation where what we need to keep in mind is that legal tech is an amazing, great solution for this group of people, and let them use it. And the question I just come to then is, what about the people for whom this isn't a good idea? And if we go so far in favor of legal tech, do we still worry about serving those other people?
Yeah, that's very, very important. Yes. On the issue you just mentioned, the relationship between regulation and legal tech. In your experience, what has been the relationship? Is it more like the opening of regulation, which gives way or paves the way for legal tech, or is it more like legal tech which arrives and forces regulation to change?
I think it's been the legal tech has people started doing it, Rocket Lawyer and Zoom, and there are some instances of things that have started and then been shut down by legal tech. But I think it has really been sort of the presence of these things on the market, and they just sort of start doing it, and then the regulators are sort of catching up and trying to prevent. But I think there's just so much pressure on the legal profession right now in the United States that they've had years and years of a monopoly to try, and they haven't solved the access to justice problem. And so I think that it's sort of regulators saying, we've got to try something else. And if legal tech is going to do it, let's try it.
On the issue of access to justice, I was wondering if you could expand on the idea of the unintended consequences of the use of legal tech. For instance, you mentioned that it's not clear whether legal tech used for estate planning is really successful on the issue of enforceability or really putting in paper the client's intentions. And maybe in those type of situations, we will find ourselves going more to court in order to address those types of issues, and maybe have a lot more cases on court, which would in time become another problem for access to justice, because we will have a lot of cases coming from legal tech, which in principle was there to help us not arrive to that point.
Right. I am fascinated by this question, and I don't think we know. And I think what people have looked at, people who are sort of proponents of legal tech, have often said, we aren't seeing a lot of that type of litigation. So we aren't seeing a lot of litigation where after the person's died, somebody's trying to contest the will, or somebody's trying to sue the company that created the will. And my sense is that you're not going to see that, because for those people to be able to bring that litigation, only people who are intestate heirs, so only people who are close enough relatives to the person who died that they would be eligible to inherit if there weren't a will, they are the only people who can sue to challenge a will. So that cuts off a whole lot of other people who might have some interest in, say, this isn't right, this isn't what they wanted, right? It's limited already, and they'd have to essentially kind of contest the will and show that it was wrong before they can then bring the other litigation against the preparer to say this is wrong. I just think that's really, we're not going to see it there.
An impossible situation.
Yeah, and there's no, and we always have this problem with wills of sort of the worst evidence or the second best evidence, because the testator, the person who wrote it, is gone. We can't ask them what they meant or what they wanted, or is this really what they wanted? And so I just think that exacerbates the challenge, which is why I'm excited about this idea of regulation shifting toward assessing consumer protection, which I think then points us toward more, okay, we need to check. We need to interview people who have used this service, and we need to look at their will, and we need to say, okay, this is what your will is going to do. Is this what you wanted it to do? Which is a different research design than kind of looking for the litigation later.
And if I understand correctly, that this type of question has not been yet addressed. We haven't yet checked with a person. This is your will. Is it what
you want? Right. There have been a couple. There have been a couple studies that have been kind of small case studies where people have looked at it, and the way they've often done it is by having something that was drafted through one of these methods and then given it to a lawyer and had a lawyer review it. And the issue with that is the lawyers sort of nitpick, and they're kind of like, well, it should have been done, this would have been better to be done this way or whatever, which then kind of brings us back to that question about what's the right comparison. Is this kind of good enough? Is it better than what they would have had with nothing? Is under intestacy? So I think there's more. The other thing I will say is I had my students who take my wills and trust class, who are mostly 3Ls. Last year on the first day of class, I gave them all a California statutory will form, just the way it appears in the statute. And I asked them to all take it home and execute it, fill it out, do what they thought they needed to do. And of course I had to put big notation on it. This is for education only. It's not a real will, and then I took them back. We said nothing more about it till we studied wills, and we studied will execution and will construction. And then I handed them back and I said, okay, how'd you do? And they were like, oh my gosh, I didn't sign it in front of witnesses. I filled this part out wrong. This is not what I want. So totally anecdotal, but I think there are a lot of questions.
Yeah, it's true, and it shows the kind of the fact that when we use legal tech in this type of situation, we may create like a sense of security because we think that we have like an expert opinion at the same time, which is not really the case. We just have a tool which does not take in account anything other than let's say the algorithms behind it and the law behind it, but nothing else. So it's really a false sense of security.
Yeah, exactly. And I think one of the other interesting kind of models is, so LegalZoom or Rocket Lawyer, some of these companies, you can either just buy the form and it'll fill it out for you, you print it out, or some of them give you an option to actually then meet with a lawyer or have a lawyer review it. And I have a lot more security there because then you're getting this other help, and it's a person help, and they could help you do the execution ceremony or talk you through how that's going to work. So I think to some extent, I am sort of making this stark, I'm assuming here kind of legal tech as fully substituting. And it may turn out that doesn't work, but that legal tech that does part of the work, but then also connects you with a human is what really works.
So legal tech would be like a starting point in order to start the reflection, determine what we need, what we don't need, and then examine the result with someone who is able to tell us what would happen with our will or what wouldn't happen.
Exactly. And Becky Sandifer often, when she talks about it, will give the example of airport check-ins. So those kiosks. Remember when we used to travel? You'd go and you check in. And for those of us who fly all the time, it's 2 seconds, you've got your boarding pass, off you go. Or the ones of us who are really with it, we've just got it on our phone. We're not even going to it. But we've all seen those people at the kiosks who are totally discombobulated, have no idea, can't do this, which is why they have to have the person there. There always is the airline person kind of walking around. And so I think that's sort of the same thing, is that maybe legal tech by itself will help and be great for some people. And maybe, but maybe we need that human piece for others.
Okay, yes. And one last question on the tools of legal tech that you have evaluated. Are they all offering the same service of drafting the will, or do they have other options? Like you mentioned, the option of having a lawyer at the end. Do they have options like kind of, let's say, a little education on how estate planning works, or anything of that kind, which would prepare someone who is a lay person to at least to grasp a little bit the complexity of the issue in front of them when they are drafting their will?
Yeah, that's a great question. I think there is plenty of kind of information available on the web, but it often just sort of exists on its own. And then I think within these programs, they do give some information as you go along. So there is the desire to kind of, do you want this or do you want that? And so I do think there's an attempt to kind of put some information in there. But how extensive that is and whether it's really enough that people are grasping it, or do people even read it, would be another fascinating question. Do people just, next. So I think that's another question about how are people actually engaging with these tools? And even if the tool provides that, do they use it or not?
Yeah, it's true. And I was really surprised by the results of your research on who uses the legal tech. I thought that you were going to tell us they are all young people, they are highly educated, and things like that. Have you thought of any explanation on why it's so? You mentioned the fact that you had maybe a too little of a group, but even at that state, I would have thought that at least young people and highly educated people would appear as being mainly the people who use it. So do you have any answer, even if it's very, very fragile, let's say?
I like the word fragile. I think part of it is that we have to remember how much selection goes into who even has a will. So there are few young people. There are many more older people there than young people. So already, like, so many of these patterns are built into who actually bothers to have a will, that I think then looking for those same things to be pushing on how they generated it is hard. So I think that's part of it, is already the young people who we see here are pretty motivated because they've managed to get an estate plan kind of early in their life. And so I think that's part of it, is this sort of selection that's already going on. And then, I was surprised too, but On the other hand, I feel like legal tech has aimed itself at sort of middle income. And the idea being that super wealthy, they are going to need estate planning more kind of for wealth and tax reasons, and they're going to go to a lawyer. And so it's kind of it's not shocking that sort of we'd see it across kind of the middle, and we wouldn't just see a pure like income increase. So I think part of what's going on is also thinking about the larger ecology of other ways that people are getting, access to this. But I was surprised too. I mean, I thought I'd see an education. I thought I would.
Yeah. I was really surprised too. Yes.
Yeah. I mean, and the other thing I will also acknowledge is this is an online survey. So to the extent it skews toward tech people. And that's again, if somebody wants to give me tens of thousands of dollars to get a probability sample, I would love to know more. But that's one other possibility is these are all elevated tech people, and that would affect more kind of, especially as among older people, they're the tech ones who would be doing this.
I'm going to thank you very much. It was a very interesting presentation. It was really thought-provoking. I really loved getting access to your results from your research. It was very, very interesting. And we had a really nice discussion too. I hope our audience has appreciated our discussion too and your presentation. It was very, I repeat myself, but it was really interesting.
Well, thank you. It's been such a pleasure. Thank you so much for having me.